Let's wait for 2 minutes. More people are joining, and then we can start. So how should we shape it up quickly? So it's a free floating one. So we have questions. So Dhruv, I will ask questions to you, and then you can put up the other questions towards her, and we can just take it from there.
Yeah. However you think is right. I think we are live though, Himanshu. So I also want to be conscious of time. Are we all joining from the same city? So what part of the country are you in right now? You're in just a short, that's all.
I'm in Delhi only.
Achha, I'm also in Delhi, sir, but in a sweatshirt.
So I'd come Delhi yesterday.
Okay.
Will be again out tomorrow.
Okay.
Okay, let's start then. I think looking at the time, it's 5 minutes up. So let's kick it off. Hello and welcome everyone. This is Himanshu, founder and CEO of GoTrust. Together we have Dhruv Suri, who is partner at PSA Legal, and we have our esteemed guest, Rakesh Maheshwari sir, ex-MeitY. So,
thank you.
Welcome, sir. Welcome, Dhruv. Focus of today's discussion will be to demystify all the questions which you have regarding the consent within the new rules which has just come up. So, and consent is also a lot of topics has been discussed, and we will focus specifically on the consent regime and its implications. We go deep dive today on few specific topics, which will be more on the user rights, consent responsibility, and the structured implementation and the timelines of it. Yeah? So let's kick it off. The purpose of the session is to give you a deep dive on the DPDP rules related to the consent. So we go there on high level, we structure it. Then we'll focus on your consent part for the data fiduciary and the consent part for the data principles. At the same time, how they are related and how we have to shape it up. Then we also go further deep into the DSRs and also talk about bit on the parental consent. So there are a few things which we will be shaping up in our discussions. So a little bit on the basics about why now, what's happening with the regime. So I will just go and ask a simple question to Dhruv, because he's a lawyer and he can explain us why now, what are the implications on it, so that all the audience were not well aware of the regulatory compliances and related aspects of it. Dhruv can put a bit light on it. Dhruv, please go ahead.
Sure. Thanks, Himanshu. Thanks for having me here. Very relevant topic. I think we've spoken about consent a lot. There have been people who have also been rather critical that consent is really the predominant basis of processing personal data in India, unlike GDPR. But I think we are way past that stage now, and I think we all need to acknowledge, understand, and start evaluating the implications of integrating consent in our day-to-day business operations, right? This is something that was known to us since 2023. And now it has essentially become a reality. The act was in force. The rules were in a draft state. The rules have now been notified. There is a timeline when the act will now be formally implemented, when all of this will become relevant. Consent assumes more significance because in terms of timelines, the shortest timeline going forward is 12 months when the consent management manager framework will be in force. And that is a very critical framework, keeping in mind the emphasis on consent as far as processing personal data is concerned. And then, of course, everything else in terms of notice and all other requirements pertaining to consent, DSR, etc., will trickle in 18 months from now. Now, given the fact that there is a strong emphasis on consent, I think organizations have already started having conversations, and some will start now, in terms of ensuring that their internal data flows have consent mapped to whatever PII they process, right? What personal data is coming in? Is it mapped to consent? What is the purpose for which that PII was collected? Who all will it be shared with, etc. So that internal mapping of PII with consent is going to become extremely critical. And and I think given this very rightly in some of the sessions that I've been a part of or I've attended, there has been a great emphasis on actually ensuring that the right technology is in place for companies to manage this entire consent architecture in a seamless manner. Because just imagine a situation where anybody comes to exercise their rights as a data principal, right? And I'm just thinking sort of not from a fiduciary perspective, but from a data principal perspective. And they come and exercise rights. When they come and exercise those rights, as a data fiduciary, your ability to be able to map that request with what personal data you have, the fact that it is, what consent was taken, what was the purpose for which that consent was taken, and whether that entire personal data has actually been used for that purpose or not, will become very relevant. And you can't do this without any technical solution. So a lot of those conversations I'm seeing now, at least in the last month and a half, have also picked up quite significantly. So it's a very interesting phase that we are getting into.
Dhruv, I will interrupt here because I totally understand. It's a very exciting phase here and also a lot of confusion in the market. So I would love to ask Rakesh directly, the one who have been the founding father of this all confusion. And sir, if you can put us some light on it, specifically on the consent part when it comes to data fiduciary versus data principal, how these two are correlated and what's the difference between them?
So as far as, it's a relation between the data fiduciary and the data principal. And this relation is being cemented by the consent notice which has been given by the data fiduciary and agreed in part or full, or maybe not agreed, by the data principal, and data principal has right accordingly. Of course, simultaneously, data fiduciary also has the ability to convey, that these are something bare minimum to be able to provide the services that are being expected by the user, by the data principal who is trying to get onboarded on the data fiduciary. So the only thing which is therefore required is, one, that it has to be lawful, it has to be fair, it has to be transparent, it has to be itemized, it has to be in a way understood in a language which is understood by the user. And of course, if you are below 18, and there are certain platforms where it is likely that you are below 18 also, as to how exactly it gets, how exactly, you give the consent. Actually, your parent or guardian gives the consent. So, and in such a scenario, maybe some sort of an age is also captured, so that as and when you become above 18, maybe you are able to take control of the consent that was given earlier, either revoke it, continue, or maybe whatever correction, updation that you may be asking. Of course, the law also requires that the way it is being taken, it should be the same simplicity with which, the same simplicity also needs to be provided so that it can be withdrawn. And in my opinion, people may not understand consent very well to begin with. So it's a good amount of user education which goes into it. From a data fiduciary perspective, the immutability of it, the ability to give proof of what consent was given, and in many scenarios just-in-time kind of consents if they have been given. So those kind of obligations the data fiduciary will have to have, and the systems have to be put in place to meet those kind of requirements.
Thank you, sir. I just skipped few slides because the content was flowing through, so I was wanted to make the audience connected. So that's the reason we switched some slides.
Okay.
The question which I think a lot of my customers are asking, and a lot of like Dhruv mentioned, a lot of discussions is happening, and we love our listeners to get a clear sense of understanding on the part is still on the it is on the organization versus the fiduciary part, where data principles are, need to map the consents. Now, that's why we specifically had this slide on the consent manager, where who are consent managers, right? How the interoperability requirement is, will be implemented, or let's have a idea of what we have to do as a consent manager to make sure this is there. Because if a company is working with a consent manager and for XYZ reason the license is revoked, how the consent has to be transferred. And not only this is one way to look at it, on the other side we can look at one consent manager is working with 10 different data fiduciaries. How the consent is now then interoperable between them versus between all the companies towards the consent manager. And then there is also a situation where we have, let's say, X amount of consent managers in the market, and I myself is purchasing a specific product or buying a specific service from companies who are on different consent manager platforms. And all of them needs a mandatory consent from the point that the Aadhaar authentication is there or some kind of authentication is implemented. So this also creates a bit of a confusion in the view from the customer point of view. When I got a lot of questions after the law was passed, okay, how will you manage it? What you should do? So that's the reason we put this slide, and I will put my thoughts here, how I'm thinking at it, and then I would love to have thoughts from you, sir, and also Dhruv, how you are thinking. So as a solution provider for the consent, we are thinking it into two building blocks. One, a consent management for data fiduciaries, which we call it a universal consent manager, because there we have just not collecting and managing the consent with the immutable records, but we also have a core processes of the organization connected with the consent. For example, consent expiry, then the retention will come, and as soon as the retention is expired, we trigger the DSRs, auto deletion, auto migration. A lot of things are bundled up when we just call it a universal consent management solution. And then there are also processes. For example, if my sales process is changing, so today I was collecting one PII, and now in the sales process I have changed, and now I'm collecting two PIIs. Now, if I do that, then my processing activity is changed. So DPI is being done by the tool, and then you go further, and then your processing activity today was mapped with one PII, and now it's mapped with two PIIs. Plus, it is also possible that you are giving the specific information or data to a vendor, and when two PIIs are in place, you're giving this data to different vendors. So there's a lot of things happening behind the scene, behind this word consent manager. And that's the reason I just put it down into chunk one, which is our universal consent manager focused on the data fiduciary side. Then we go to the data principal side, where again the consent manager is there, and that's we have coined the word as a consent manager itself. There, the consent manager act as an aggregator, facilitator to manage the record of the consent. And then it enables the data principals in case of any issues or any challenges he's facing with his consents, where his records are not being deleted, or he's having some trouble to get his consents, or let's say his voice heard to the companies, so he can raise a complaint and other things can happen. The standard part is there, of course, where his consent is managed, but I'm just further extended features which you're talking about. So I am thinking from these two point of view. And now I would like to hear, Dhruv, how you think about it, and then we'll go to the Maheshwari for the final stamp on it.
Sure, Himanshu. I think that's, I think you're largely right, but let me just sort of take a step back and look at the consent manager framework in terms of how the law has prescribed it, right? What is the legislature thinking when they think of a consent manager? It's sort of very similar to the account aggregator system that we have right now as far as the RBI is concerned, right? So within that whole sort of banking, fintech, NBFC ecosystem, account aggregators will essentially manage consent on behalf of customers. And you can so essentially think of it from the perspective of a data principal, where a data principal logs on to one central dashboard and can manage consents that it has given to, say, 20 data fiduciaries. Okay, but that obviously requires that the consent manager sitting in the middle has those 20 contracts with the 20 data fiduciaries, right? So it's essentially to ease the work for and ease how a data principal will manage and give and withdraw consent. But the framework, as far as the consent manager is concerned, is limited to consent, right? And like you said, there's a lot more that goes on behind the doors as far as an organization is concerned. So whether today organizations, or when I say organizations, I mean data fiduciaries, whether they'll feel comfortable onboarding consent managers separately just for consent, but also then onboarding like other players in the market who will help them with everything else that is in addition to that, like we discussed in terms of, new processing activity that comes in, your ROPA, your DSR, etc., all of that. Or is the expectation that our present vendor, who is going to come and give a lot of these services, will also be registered as a consent manager with 𝗗𝗵𝗐, where essentially for the consent piece, they are going to be regulated, but for everything else, it's part of the ecosystem and they can continue to provide those services, provided there is no conflict with the data fiduciary, right? Because one of the questions that we had also raised during the deliberations that happened was that can the consent manager do other businesses? Because today, if you are a consent manager and you don't manage to onboard, because you can't charge any money to the data principal, right? So your actual revenue is going to come from data fiduciary. So if you don't manage to onboard a lot of data fiduciaries, then how will your business model work? So if you're also doing other businesses, is that something that's going to be permitted? While it's not expressly mentioned, but the sense we got is, yes, there is no restriction per se on that. So my sense really is that the framework, the way it's been thought out is, it's an intermediary platform in the middle that has a fiduciary relationship to the data principal, but will enter into contracts with data fiduciaries and manage consent and everything that goes with consent on behalf of the data principal. That's the broad framework. And in terms of how it's implemented, like I said, we'll have to wait and watch, because one of the big risks I see from a data fiduciary perspective is that if something goes wrong as far as the consent manager is concerned, right? I mean, they've gotten their permissions from the regulator to operate as a consent manager. What if that is withdrawn? Then what happens to that entire consent ecosystem that is being managed by this third party for them? So are they better off working with them, or should they better off working with somebody whose license can't be taken away and therefore there is no disruption? I think that as we see businesses evolve, we will get better answers to that.
So let me get a stamp on your words, Dr. Maheshwari sir. Sir, your views on it.
So I mean, very, very clearly brought out by you, Himanshuji, I mean, as to the two business models which can exist in the form of consent managers, and very correctly conveyed by Dhruv when he particularly talked about the account aggregator model, which in a way was the central theme at the time when the drafts were being made. And naturally, I mean, innovations are always possible. So therefore, I start with maybe something what is there as account aggregator. And this is not just about account aggregator in finance. It can be in health. It can be in any sector where particularly you are wanting to share the content related personal information. And therefore, I believe that when we talk of personal information or personal data, in fact, it is something which is about you. It is something about your metadata in terms of the transactions that you do, and it is something also in terms of your actual content. So maybe if I book a phone, I fill up a CAF form which is about my BSI, but basic subscriber information, which is personal data. Then I make the calls, the duration of the calls, to whom I have called. So such kind of detail are metadata and also relating to you, and hence they are the second kind of personal data. And the third kind is the actual content, which therefore the communication which actually happened. Now this communication also in a way indicates my behavioral pattern, and which is what is likely to be shared amongst the data fiduciaries, particularly to enable ease of doing business, maybe ease of sharing the authentic information, authentic personal data with the other data fiduciaries. So naturally, consent managers will therefore have to follow clear standards so that the interoperability is possible. Even if one goes down, there should be reasonable good amount of redundancy, and that's why the whole, I mean, if you look at from the timeline perspective, everything has been, I mean, with respect to consent managers, has been opened from year one, so that maybe they evolve, they find a suitable business model, and that there are good number of consent managers in a particular business. I believe that the resiliency automatically comes in. So other examples can be, as I mentioned, about health. In fact, in Karnataka, we had a good example, I mean, particularly in micro lending, where maybe land is, or data about the land, data about the crop, which otherwise cannot be seen or cannot be shared unless you visit the place. Maybe those data are shared to the I mean, potential lending agency, and once the crop is there, maybe the payments are done and done away with. Consent manager very conveniently fits in. The universal model is something, I mean, which is where maybe to begin with challenges will come, because that is something which has not as yet evolved. Logically it's possible, but then standards will have to be defined, so that the interoperability requirement, and the additional requirement is that you should be able to withdraw means, you have mentioned that auto deletion within the context of the data fiduciary who has got the data is actually going to be a tough thing. So
Correct, sir.
in the conventional account aggregator model, it works very well, or something similar. But in universal model that you have talked about, maybe otherwise also over a period of time, standardization protocols need to be developed. And to begin with, maybe it's the account aggregator and similar kind of models where the consent managers will come, because they already exist more or less. And the second model is one which will evolve over a period of time.
Agreed, sir.
But 1 year is where the consent managers start getting registered. It's an ongoing process thereafter.
Correct. So one thing you mentioned about the delete thing, that's, I think you meant forget me, like in Europe, all the websites now offer forget me. Then data fiduciary has to delete all the records or anonymize all the data of the data principals, so that data cannot be used, or at least cannot be stored in place. There are two questions asked. One was like, outside of managing consent, does the consent manager also act as a data blind pipe for similar data to AS? So similar thing we discussed, and the question was who pays, how the service model works. So Dhruv, thanks for clarifying how the service model is. It's still complex, being developed further, but at least give some idea. Another question was asked by Mr. Manish, and it was, in an organization, when it comes to consent, can we add clauses in the employee offer letter to get explicit consent? I think this is already covered by the law. That's the mandatory consent. certain consent has to be taken, but the justification has to be there. Why are you processing the data of the employee? And again,
If I may just
yeah, I think one more thing, Dhruv, was in the policy, it's written also, right? How long you can keep the data after the employee has exited the company and so on and so forth. So if you can add something on this part, on the employee part, I think Manish will be at least get the answer.
Yeah. So according to me, this will be a very sort of this will have to be managed and handled very sensitively for two reasons. One, uh, if you're processing employee data, quote unquote, for the purposes of employment, then you don't require consent, right? That's the exception to consent. The minute you process any data on the basis of consent, right, just because you're trying to be overcautious, then remember the consequences happen once that consent is withdrawn, because that purpose of processing is now linked to consent. Therefore, this whole assessment of when does actually purposes of employment begin and what is the processing that you can do under the overall blanket purpose of purposes of processing, right, for purposes of employment. So if it is linked to employment, then it is best not to actually go down the consent path. But if it is not linked to employment, then of course consent is a good model and has to be the only model. But the tricky part also in all of this is, when does purposes of employment begin? Does it begin when you execute an employment agreement? Does it begin when you start scouting for resumes but don't actually have a contractual relationship with the employee? What happens to subcontractors? What happens to contract labor? So there are a bunch of very sensitive issues around employee data. Okay, so I don't think the answer is a very yes or no answer.
Sir,
But
sir,
I
I
would
may add a simple scenario, because I was asked this question. The question was that there is surveillance. The camera is there in the office canteen, and the reason for that camera is that employees are allowed to take 15 minutes break in a day, and it only observes that if people are sitting more than 15 minutes, then the security is going to come and tell them, sir, your 15 minutes up. So where will this fall, and how the consent will work on this in this manner? And again, data can be used later in case employees, has found too much into the cafeteria or non workplace. Mostly it happens in the manufacturing area, but still, would love to hear this thought also from you, because
so
a difficult
again,
question, but yeah, sorry.
and I'll tell you, this is the reason why the law is not prescriptive, but is principle based, right? It allows you that level of flexibility to be able to evaluate such situations. Today, if you go and get an opinion, a legal opinion on what this is, it can go either way, right? But the truth of the matter is, you need to evaluate as an organization. Can you justify why you're collecting this data? Say if it's safety or if it's to ensure timelines. Because if you link it with consent, then what if someone doesn't give you consent? A CCTV can't work where someone has given consent and someone hasn't, right? So if you're linking it with purposes of employment, then you'll need to create some sort of a policy around it in terms of how soon this data is deleted. Because if the purpose is, I want to ensure that they are not taking more than 15-minute breaks, then that purpose is accomplished as soon as that 15 minutes is over, or perhaps the very next day when you know who's taken a more than 15-minute report, right? So those level of assessments will have to be done in processing like this. And for instances like this, you could consider that in terms of your employment contract, you are putting in some sort of a generic clause. But again, it has to be carefully evaluated, because like I said, you want to ensure that as much of the purpose, as much of the processing of employee data is concerned, for the purposes of employment, is kept outside of consent, because that will become a little bit of a problem for organizations if they also take consent for something that they don't need to.
Perfect. Thank you,
Yeah,
sir. Professor.
maybe.
Maheshwari sir, yeah, please, if you want to
Yeah,
add a
so
bit on
I'll
it.
also just like to mention that let this not be overread. Let the organization, so naturally organization has every right to put these kind of things, maybe biometrics, maybe CCTV cameras, and so unless it is put in a public space where non-employees are also visiting, then it's a different thing. But with respect to employee, it's a different relation. And what is more important is, how does the organization ensures security of such kind of data? retention, it's always better, it's always good. Maybe they define the retention period of, naturally they will have to define retention period of such data, which I always believe shall be pragmatic, has to be pragmatic, and that's it. So unless it's a public place, no need to overreact. For whatever purposes it is used, it's the employer's right to have such things in place. But
Sir, I think
simultaneously, responsibility of defining the retention period and ensuring security of data while in possession of the data fiduciary or employer, whichever way it is.
You very rightly said about the retention period, because collecting the data is one of the challenge, and why we are collecting that is from the purpose point of view, and how long the data should be kept for what purpose also is very important. The retention is defined, because majority of the problem comes once this data goes into public domain by the hacker or by certain actions which should not be done there. So I think with this note, I will say thank you to everyone. Thank you to Maheshwari sir for the deep dive on how the thought process was 2.5 years back when it was built. Thank you, Dhruv, for taking us with your legal angle on it. So once again, thank you, everyone. We'll come more live in coming days to demystify all the challenges, complexity. We are also understanding it, talking to a lot of organizations to come up with a better understanding and bring these insights to you guys. So thank you once again. Thank you for listening. And if you are not live, listen it later. Thank you guys again. Once, bye bye. Thank you.
Yeah, thank you very much.
Thank you.